Senate Bill 43 reestablishes the balance between employment discrimination issues. As a business owner of over 29 years, the pendulum has swung so far that the courts are in favor of the plaintiffs, and it's time to create a balance between business owners and the plaintiffs. This bill is presented to rectify some past court discretions.
The result is a regime where allegations trump evidence, where proof that a defendant actually caused the alleged harm is no longer required, and where defendants have no choice but to either pay money to settle baseless allegations or else to expend substantial financial and other resources to defend such claims all the way through trial and appeal.
If we continue with a scheme that provides different and, in my humble opinion, inappropriate protections, this state is put at a competitive disadvantage with regard to attracting employers, retaining employers, and having a vibrant economy in the state of Missouri.
What's really happening is we're actually seeing kind of a turning, in my opinion, where employers may not take action because they may be ultimately afraid that something may happen with reference to potential litigation. So what is that doing? That's hurting overall morale within the workplace.
Recently I had a high school coach who was subjected to a racial slur by one of his students. In response, the coach, caught up in the passion of the moment, physically engaged in an altercation with this student. In the wake of the incident, the school investigated the matter and determined the coach should be disciplined and possibly separated from employment from the district. When the administration approached the coach about the potential for the disciplinary consequences, the coach explained that he had spoken to an attorney, and if the district disciplined him in any way, the coach would sue the school, and the claim would be for race discrimination. It would be very difficult in that setting to explain to a jury how his race did not contribute in some small way to the decision to discipline him for engaging in a physical altercation with a student. That's just one example of what we deal with.
I've sat through excellent plaintiffs' lawyers making closing comments and hold up a piece of paper, a legal pad like this, and tear off a corner for the jury and hold it up and drop it and said, that's what a contributing factor is. Do you think this employer did not know what my client's gender was? They didn't know what their race was? How could they not consider it? And that's why we need to go back to where Title VII has always been, where the Missouri Human Rights Act was been, because of...
Something I do want to point out. We are proposing a large umbrella tort reform agenda this year. And a lot of the items that we are advocating for are things that are in effect in other states. But this particular proposal is unique to Missouri because Missouri has become an outlier in its application of its Human Rights Act. The legislature over the last 50 or 60 years amended this law about 8 times, and they very well could have changed the factor. They could have changed the language from because of to motivating or contributing, but they didn't. And the Supreme Court took it upon itself to adopt that contributing language. What you've heard from today are a lot of different lawyers who represent a wide swath of employers, from Fortune 100 companies to school districts. And what we're hearing time and time again is Missouri is competitively disadvantaged because of the way this law is being applied. And I want to harken back to the testimony I gave last week with respect to the Templemeyer case. Employers are operating their businesses practicing defensive business judgment. They are not operating with the way that they should, the way that they feel that they should be able to demote or discharge someone because of their conduct, and because of the law that it's being applied right now, it's being applied in much broader scale than that Templemeyer case.